Welcome back everybody to our studies in land law. In this lesson what we're going to do is move on to the next major topic in this series of lessons, focusing on trusts of land. We'll take an introduction to the concept of trusts of land in this video, and then in the next few videos we'll talk about the distinction between constructive trusts of land, the duty of trustees in relation to land, all of these different elements and all of these different ideas. Now, this is really the part of land law where we see the most interaction between this subject and the law of trusts, as you can probably imagine. Hence, we're talking about trusts of land. So it is often advised that you at least maybe watch some of our videos on the law of trusts, just to get a basic understanding of what a trust is, because the point here is that we're not going to just go through the intricate details of the law of trusts in this video. You sort of are assumed to know at least a little bit about what a trust ultimately is in these lessons, because we're talking about the law of trusts essentially as applied to land and to property. The main area of law which is regulating the trusts of land is the Trust of Land and Appointment of Trustees Act of 1996, the Talata legislation. This is the major statute that we're going to be referring to back and forth in this next few lessons, but we will refer to some case law as well at points. We will explore some of the first provisions of this legislation in this lesson as well. So we'll talk about essentially defining what a trust of land is and the elements of the trust of land legislation. So, a trust of land. The question that we have to ask is, what is a trust of land? Well, given the definition of a trust of land, it is actually quite broad in terms of its definition as applied by Section 1 of the Talata legislation. In fact, Section 1 says the following. It says that in this act, a trust of land means, subject to subsection 3, any trust of property which consists or includes land. And trustees of land means a trustee of a trust of land. So let's just take a little brief pause and let me just explain what a trust is in the quickest way possible without going into the intricate details. Like I said, if you want to know more about what a trust is and how trusts work, you should go and have a look at our Law of Trusts videos that we have already and we are releasing in conjunction with these land law videos. Ultimately, what a trust does is establish a transfer of property to an individual who then holds that property on trust for a beneficiary, for somebody else. Okay. Now, the person who transfers that property, who is the original legal owner of that property, has both the legal and equitable title to that property. And they are known as the settler, or if they are dead, they are known as the testator of that property. When they then go and they transfer that property to a third party, that third party becomes a trustee of land. In this case, sorry, a trustee of land as defined in the Talata legislation here, a trustee in general. And what they do is they take ownership of the legal title to that property, but on the basis that they are holding that property and that they can only do with that property what is defined in the trust instrument. And they are holding that property for a third party. So they are holding that property for a beneficiary who will have equitable interests in that property. That is the basic structure of a trust. So when we say a trust of land, we are talking about a trust which has property which consists of or includes land inside. So the legal title that is being transferred is land, is in relation to some kind of land, whether it be, i.e., more specifically property in terms of a house, for example, or a section of land or a field, anything like that. A trustee of land means a trustee of the trust of land. The reference in subsection 1a to a trust is to any description of trust. So this can be an express trust, it can be an implied trust, it could be a resulting trust or a constructive trust. And it could also include a trust for sale and a bare trust. And includes a trust created before the commencement of this act as well. So that's a little bit of a technical provision which allows for the Talata legislation to regulate trusts of land which existed before 1996. The reference to land in subsection 1a does not include land which, despite section 2, is settled land or land to which the Universities and College Estates Act 1925 applies. So those are the two exceptions to the land which is going to be regulated in relation to section 1 of the Tolata legislation, or at least section 1.1 of the Tolata legislation. So let's just finish with a basic summary then of what we're talking about when we examine trust of land. So from reading the passage from the previous slides, from reading the Tolata legislation, we can summarize what a trust of land is. Okay, they are a trust property which consists of or includes land. Okay, the property itself either consists of or includes land. They are either done expressly or impliedly, so that's where we're talking about resulting, constructive, express, implied trusts, all these different types of trust instruments which could ultimately be used in trusts of land. They must have arisen before or after the 1st of January 1997, and where they are implied, they can either be implied through a resulting trust or a constructive trust. Again, see our lessons on the law of trust if you want to know more about those, but we will get into them in relation to land law as well in the future lessons that we do on this topic. In continuing our discussion of trusts of land, in this video what I'm going to do is explain the idea of an express trust of land. We will talk about some of the provisions within statute that relates to the express trusts of land, and then we will also examine one of the major cases in this area as well. We'll look at the creation and regulation of an express trust in land in this video, in this lesson, and we'll talk, like I said, with some case law, examination of some case law, and some examination of some of the basic provisions relating to the express trust of land. Okay, so when we think about an express trust, we have to think back to our previous videos where we've spoken about the idea of a trust. The idea of a trust is the transfer of some kind of property often it is from one person to another or from one organization to another. And this transfer of property is then held on trust for the benefit of a beneficiary. And so within the basic structure of a trust instrument, within the basic structure of a trust in land, an express trust in land, or an express trust in general, you have a settler or a testator who transfers the property, the legal title of that property, to some kind of trustee, who then holds that property on trust for some beneficiary. We've explained this multiple times already. We have a number of lessons exploring this idea on the Law Academy on the law of trusts. So you don't need to know anymore, and I don't need to explain anymore. If you want to know more about this, go and have a look at those lessons over on the Law of Trusts playlist. When it comes to an express trust in relation to land itself, it will be created through the use of a self-declaration. And this is done in accordance with the terms of the Law of Property Act of 1925. Section 53(1)(b) of the Law of Property Act says that a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. This is the provision that is established for the creation of an express trust in land. And when it comes to the various different elements that relate to interpretation of this provision and the way in which the case law has provided and has been provided for this provision, I can point you to the case from 1970 of Petit and Petit, again from 1970. The facts of this case are as follows. This was a case where you have a married couple, hence the names of the claimant and the defendant being the same, with the wife being responsible for the purchase of the matrimonial home and the conveyance of that property being done in her name. So for all intents and purposes, in terms of the legal ownership of the property, the wife had purchased the property, the conveyance was done in her name, she had legal title to that property. They had both, the husband and the wife, had both lived together in the house together, in the property. And when the marriage broke down, the husband tried to make the argument that he had a beneficial interest in the home, owing to the fact that essentially the question of whether or not the husband was able to make a claim for an equitable interest in the property by way of some trust that existed. One argument that was presented related to the improvements and decorations that were performed by the husband. And so if you look back to previous videos that we have done on this topic, if you remember, a lot of these trusts in land issues and questions relate to the idea of there being some kind of married couple or some kind of couple who, or people who are intending to cohabit in a property, where one has the legal ownership of the property. They have the legal title, they have the legal deeds, or whatever it is through which the conveyance takes place. But it is the case that the other person, while not strictly on the legal documentation and is not strictly a legal owner of the property, maybe still contributed a significant amount of the asking price. And so in that regard, an implied trust existed with relation to that, the equitable interest that was made in relation to the contributions to the asking price, sometimes known as a resulting trust. This question here related to the idea of there still being a matrimonial home, which was in the name of one of them in terms of the legal ownership, but the argument that was presented wasn't necessarily that the other person had contributed significantly to the asking price. One of the issues here in the argument was that they had contributed significantly to improvements and decorations which were performed by the husband, and so in that sense that entitled them to some kind of equitable interest in the property. The court held that the decorations and improvements, the argument that was presented by the husband, did not, in and of themselves, give rise to an equitable interest in the property, that there needed to be a little bit more than simply going in and decorating and improving that property in order for there to be an equitable interest to arise out of the establishment of this equitable interest in the property. And so as a result of which the husband had very little to go off in terms of making that and presenting that argument to the courts. In the previous lesson, we talked about the ways in which and the process by which a trust in land has to be created expressly. We talked about the concept and the creation of an express trust in land as cited by the Law of Property Act, the declaration to establish an express trust in land. In this video, we're going to talk about the trusts in land which are slightly more common in terms of that are at issue for those of you who are studying land law, which is the idea of an implied trust of land. We'll talk about what the statutes and the statute law says about this particular area, as well as look at a couple of cases that examine this in more detail. So, like I said, the previous lesson explored the express creation and regulation of trusts of land. This lesson is going to talk about how a trust of land may be established impliedly. So, according to Section 53, subsection 2 of the 1925 Law of Property Act, there will not be a necessity, there is not the necessity, for the formalities in creation of an implied trust in a similar way to that exists when we look at an express trust. If you remember back to the previous lesson, we spoke briefly about the Law of Property Act and the provisions which essentially require there to be certain formalities in place in order for there to exist an express trust in the land. Section 53, subsection 2, however, of the Law of Property Act from 1925 says something different. They say that this section does not affect the creation or operation of resulting, implied, or constructive trusts. And so, ultimately, when we think about the various different types of trust in land which may be impliedly created, one of the most common of these is this idea of a resulting trust in land, where there is another party who has contributed to the asking price of a property, even if they are not specifically the legal title owner of said property. The legal title owner of said property may have to hold on trust for those who have contributed to the asking price. This is known as a resulting trust in land. So, this is in relation to the proportion of their contribution. Okay, we'll get to how this is established in the case of Dyer and Dyer in a second, but ultimately, this is really where we see the majority of resulting trust in land be established. You have two people. In a lot of cases, they are in some kind of relationship or marriage. They are purchasing a matrimonial home, and often, mostly for the case of simplicity, or maybe for logistical simplicity, one of the people who is purchasing the property will put their name down and have the legal title of the property itself. They will have that legal title, but at the same time, there may still be the existence of both of these people contributing quite a significant amount to the asking price. In some cases, it could just be 50-50. And so it is held that in order to essentially represent the interests of the other person who may not be strictly holding that property on a legal basis, but they still have contributed quite significantly to the asking price, there is this view that they should have some kind of rights in equity to have an interest in that property, which is what a resulting trust of land presents. Now, the way that this is calculated, as soon as it has been shown that a resulting trust of land exists, it will be calculated on the basis of the proportions of their contribution. We see this in the case of Dyer and Dyer from 1788. Okay? This is a very old case, as you can tell. In this case, an individual had provided money for the purchase of a legal estate, which was going to be conveyanced by another person. So a very simple transaction that exists. There was no evidence of the purchaser making a gift, and as such, it was assumed that the legal purchaser of the property would be holding that on trust for the individual who contributed to the asking price, to the purchase price. So given the fact that there was no assumption that this money that went towards the contribution of the purchase price was actually made for the purposes of a gift, it was therefore assumed that if it wasn't a gift, then it would represent a trust. It will represent the existence of a resulting trust. Of course, this speaks to one of the maxims of equity, which states that equity will not perfect an imperfect gift. So you have to be very clear when you're presenting a gift, and you do not and should not rely on equity to perfect such an imperfect gift. So this was argued in the courts, and the courts held that this was the case, that the property was actually held on trust, and that this represented a resulting trust in the property. The courts say that the trust of a legal estate, whether freehold, copyhold, or leasehold, whether taken in the names of the purchasers or other jointly, or in the names of others without that of the purchaser, whether in one name or several, whether jointly or successive, results to the man who advances the purchase money. It is this subsequent passage in the quote that I have here that is what's most important for us to establish. Whatever the property is, the trust of a legal estate will result to the man who advances the purchase money. So if you put together the purchase money, then the resultant trust advances to you as an individual who has contributed significantly to the asking price, unless it can be shown that purchase money was actually a gift, in which case that would represent a gift, and there would not be any creation or resulting trust as a result. This gives rise to an evidentiary presumption that exists, the idea of it being a presumption of a resulting trust. The previous case assumed that there was a presumption that a resulting trust is created, where another individual has contributed to the asking price of a property. And so this is obviously an opportunity that is able to be rebutted, but at least when it comes to the evidentiary standard that the courts have set, the case of Dyer and Dyer tell us that essentially what happens here is that if another person has contributed significantly to the asking price, or has contributed to the asking price of a property, there is a presumption that there is not a gift in that regard. The presumption is that it is a resulting trust that has been created, and it is up to the often the defendants or whoever is trying to argue that it is a gift, that this presumption should be rebutted, that this presumption should not exist. Now, there are a number of trust cases that result to and relate to the rebutting of the presumption of a resulting trust. These include the case from 1875 of Fawkes and Pascoe. We also have the 2016-2017 case of Patel and Misra, and we also have the Henderson and Dorset healthcare case in 2020. If you want me to go into these cases in more detail, potentially as a case summary video, I will do so in future lessons' time. In this very quick lesson, I just want to run through very quickly and briefly the concept of the constructive trusts of land. So the previous couple of lessons talked about the other two major types of trusts that can exist when it comes to land and trusts of land. We talked about the express trust very briefly, and then we spent a little bit more time talking about implied trusts, namely the concept of the resulting trust. And we also talked about the fact that there is an evidentiary presumption that a resulting trust exists where there is a contribution to the purchase price of a property, and that this may be rebutted, but the base presumption that exists is the presumption that there does exist a resulting trust of land, not that there exists, for example, a gift. This lesson is going to talk about the constructive trusts of land. We'll talk about one of the key cases that illustrates the point of what a constructive trust is used for and the circumstances where a constructive trust may arise. So as I've mentioned, we have been talking in the previous videos about the first of the implied trusts of land, namely the concept of a resulting trust. The concept of a constructive trust is also a type of implied trust. It is just the other type of implied trust, which is known as a constructive trust. So when you think about the two different types of implied trusts of land, one is resulting, the other is constructive, okay? What do constructive trusts of land look like? How do they work? And what are their purposes? Well, they are firstly limited to a number of situations. And we can see why this is the case and cited in the case of Lloyds Bank plc and Rossett. This is essentially the case that we're going to use to illustrate our point about what a constructive trust of land is and how it operates. So this is a case from 1988. And in this case, a house is brought solely by one individual for the purposes of cohabitation with his partner. Again, very similar to a lot of cases that exist in this particular area, where you have the sole purchase by one person, and then you have for the reason of, or for the purpose of, the cohabitation with another person. And it is often the case that that other person has contributed significantly to the asking price. And in those situations where the other person has contributed significantly to the asking price, there is the resulting trust that arrives at the purchaser. This person who bought the house or bought the property solely for the purposes of cohabitation had taken out a mortgage with the Lloyds Bank plc. And then when he had defaulted on the mortgage repayment, the bank sought to get an order of possession or repossession order. Essentially, when you get a mortgage, you have to keep up with the mortgage repayments. And if you default on your mortgage repayments, then the bank has an entitlement, in most cases, in most circumstances, to seek an order for possession, to essentially take the property from you. Now, the partner of the man argued that, in fact, this could not have happened because they actually had an overriding interest as part of the beneficial interest under a trust. Remember, we're talking here about a piece of registered estate. So if you refer back to what we did in the previous chapter on registered land, we can talk about this idea that there may exist an overriding interest. This is what the individual who is cohabiting with the person who defaulted on the mortgage argued is the reason why the bank cannot seek an order for possession. They had a beneficial interest under a trust, and this represented an overriding interest over the interest of the bank to get said repossession. Now, it was held ultimately that there was not an overriding beneficial interest in the property. The courts held that the constructive trust in land can arise in situations on the basis of the intentions of the parties. So this is the circumstances in which a constructive trust of land can exist. They argued that there could be an express common intention among the parties, and that this suggests the reaching of an agreement, arrangement, or understanding could be the creation or lead to the creation of the constructive trust. Now, the actions that exist that can lead to this circumstance is not necessarily just in relation to the financial contributions to the asking price. If this express common intention is not stated, then it is inferred through conduct. And this is really where we get the idea of a constructive trust. And so, as a result of which, while finding against that of the defendants, and arguing that there wasn't an overriding interest in the property itself, the court come to a conclusion as to the circumstances in which a constructive trust may exist in the property.